The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Good morning. Please be seated. We're happy to have you with us today, even remotely. And we'll hear our first case, number 197340, Moss versus Harwood. Mr. Corzine?
Yes, may it please the court. Judges Motz and Diaz and Harris. So I'm John Corzine from the Wake Forest Clinic, and under Local Rule 46, it's my pleasure to introduce to the court the two third-year student counsel who will argue this morning. First, Ms. Sarah Keller will address the first issue on exhaustion administrative remedies, and then Ms. Sierra Weingartner will address the second issue on deliberate indifference to serious medical needs. Thank you very much.
Thank you.
Good morning.
Good morning.
First issue today is whether Eric Moss was prevented from exhausting his administrative remedies.
Excuse me, we can't hear you very well. I don't know exactly what's going on in your microphones, or at least I can't hear you very well.
I can't either.
Okay. May it please the court. The first issue today is whether Eric Moss was prevented from exhausting his administrative remedies.
I still can't.
Well, that's still not that good. Maybe you need to move closer to the microphone.
The defendants repeatedly prevented Mr. Moss from engaging the administrative grievance process and made Mr. Moss's administrative remedy unavailable. The lower court decision, which brings us here today, that Mr. Moss failed to exhaust his administrative remedies, should be reversed for two reasons. First, Mr. Moss was denied access to grievance forms and cannot be held responsible for exhausting an administrative remedy if he is prevented from using that remedy. Second, Mr. Moss's use of another inmate to file a grievance on his behalf should not be held against him because an inmate is under no obligation to invent a novel method of grievance filing. For those two reasons, we respectfully request that this court reverse the district court's grant of summary judgment in this matter. First.
But counsel, can I ask you, I take your point that an inmate can't be required to find a workaround if prison officials are making it impossible to access a grievance system. But if he in fact does, how can we say that the grievance system was unavailable? I mean, it was literally available. He used it. I mean, he did file a grievance.
Your Honor, in this instance, that grievance was filed for him on behalf of him by another inmate, and that his PIN number for those kiosks was revoked as soon as that grievance was filed on April 22nd, which shows that this prison does not condone use of another inmate to file a grievance on your behalf as an appropriate administrative procedure to comply with the prison's policy of filing.
It does seem to me that the prison, assuming that all the allegations here are true, the prison has done some things that might be the source of a separate claim. But are there any cases where a court has ever held that a grievance system is unavailable, where the inmate in fact filed a grievance during the time in question and under the circumstances that he claims rendered the system unavailable?
Your Honor,
has this ever happened?
Your Honor, here that grievance was filed for him by another inmate, and again, that was not a sanctioned grievance procedure by.
I understanding all of that, but a grievance was filed on his behalf under his name during the time period and under the circumstances that you say rendered that process unavailable. And I'm just asking, are there any cases where a court has ever held a grievance process was unavailable when in fact it was accessed?
Your Honor, there are two cases out of this circuit, both Moore v. Bennett from 2008 and Hill v. O'Brien in 2010, when this court held that refusal to provide those grievance forms prevents the administrative remedy from being available. That Hill v. O'Brien case, a panel of this court held in 2010, that a prisoner's ability to take advantage of an administrative grievance is not an either-or proposition, and that there are times when a remedy is clearly available, other times when it was clearly unavailable, and that there can be a middle ground in those cases. That is what we have before the court today. That standard.
So I'm sorry, how is the grievance unavailable?
Mr. Moss was consistently not provided access to the written paper grievance forms, which is required by the prison policy. The prison policy, Article 11, Provision 1, which is on page 167 of your joint appendix, only lists paper forms as a proper grievance method. If Mr. Moss is going to be held to both corners of the policy, which defendants are attempting to do here, he must be given grievance forms in order to be in compliance with the four corners of that policy.
So going back to my colleague's question, was there a grievance that was properly filed in the paper form?
There was a grievance filed through use of a kiosk by another inmate on Mr. Moss's behalf, but Mr. Moss himself was unable to file grievances during the time period at issue.
So, but you can see that there was a grievance that was complied with the prison's requirements that was filed during this period on his behalf.
Your Honor, there was a grievance filed at a kiosk by another inmate on behalf of Mr. Moss. But again, the kiosks are not listed in the jail policy as a proper means of filing a grievance. This was an unreasonable request to ask Mr. Moss to create a game of telephone. And he was released, as you'll see on page 318 of the joint appendix, he was released from lockdown for 1 hour. In that
I'm having trouble hearing you again. Maybe your voice drops away or gets blurred as you talk. I don't know what's the problem.
I will move the computer again. Is that a little bit better?
Yes, it's fine when you start out.
Okay.
Yeah.
Okay. Mr. Moss, according to page 318 of the joint appendix, was released from his lockdown for 1 hour. During that short period of time, Mr. Moss was then required to play a game of telephone to be able to get his grievance heard, because his attempts to use the proper grievance process of filing a paper form were consistently denied. And that standard is what we're operating from here, is consistent denial. Supreme Court held.
Ms. Keller, can I ask a question? You keep referring to the kiosk as an unauthorized method of filing a grievance, but I mean, it was there for a reason, and it's being used by the inmates in the course of their daily, lives. So why do you think it's unauthorized? I mean, as I understand it, those kiosks were, in fact, a method for filing a grievance, and prison officials responded to grievances that were filed via the kiosk.
Yes, Your Honor, those kiosks were installed for convenience, and it is very hard to say that a kiosk is convenient for an inmate that is held on lockdown for 165 of 168 hours in a week. And Mr. Moss, again, the only grievance that was filed during that time period from April 2nd to April 25th was a grievance filed on his behalf by another inmate. Mr. Moss was required to play a game of telephone in order to have his voice heard, rather than being able to follow the normal requested prison procedures of requesting a paper form, filling out that paper form, signing it, and submitting it to a CO as outlined in Article 11, Provision 1 of the prison's policy. Because Mr. Moss was unable to exhaust his administrative remedies, because those administrative remedies were unavailable to him, he cannot be held responsible to exhaust a remedy which he doesn't have access to and which is unavailable. As such, we respectfully request that you reverse the district court's grant of summary judgment in this matter.
Before you sit down, I have a couple of questions. First, you concede that a grievance was filed on his behalf.
Yes, Your Honor.
I thought the prison authorities, and I'm sure they will correct me on this, said that he didn't comply. He didn't ask for a hearing. That seemed to be crucial in all of their papers. Did he ask for a hearing in that piece of paper?
Your Honor, in that grievance on April 22nd, Mr. Moss seemed to have his most urgent needs met. He was in extreme medical distress, which my co-counsel will speak to shortly. And because of the game of telephone that was required of him in order to file that grievance, he needed to find an inmate that he trusted, distribute his PIN, convey all of his needs to that inmate, and then trust that that inmate could convey all of those needs to the kiosk. That game of telephone required Mr. Moss to get his most urgent needs met first, which was his medical needs, which my co-counsel will speak to shortly.
So he didn't ask for a hearing. So that's all I was asking you.
Correct, Your Honor. He did not ask for a hearing.
But then under the prison's own theory, he didn't file a grievance because he didn't ask for a hearing. And you can only have a real grievance if you ask for a hearing.
But you can also only have a real grievance if you have access to the administrative remedies.
I understand. Okay. Thank you.
Thank you.
Good morning.
We can't hear you at all.
Your Honors, is that any better?
Yes, thank you.
May it please the court, I will be addressing the second issue, and that is whether the defendants were deliberately indifferent to Mr. Moss's serious medical needs when they denied and delayed treatment to his thyroid disease and mental health disorders. Mr. Moss has put forth sufficient evidence to create a genuine issue of material fact for a claim of deliberate indifference under the Eighth Amendment. The test for deliberate indifference contains two parts. First, the objective prong requires a plaintiff to demonstrate an objectively serious medical need. Second, the subjective prong requires a plaintiff to prove that the defendants knew of and disregarded a substantial risk to the plaintiff's health or safety. Here, the defendants were deliberately indifferent to Mr. Moss's serious medical needs when they denied and delayed treatment to his thyroid disease and mental health. Therefore, this court should reverse the district court order granting summary judgment on Mr. Moss's claim for deliberate indifference. Turning to the first prong, a claim for deliberate indifference.
Ms. Weingartner, sorry, can you just move a little closer to that computer? You start off, as Judge Mott mentioned to your colleague, you start off strong and then you fade as you go on. So it's hard to hear, and we want to hear you.
Now we can't hear you at all.
How is that, Your Honor?
That's good. Just stay right there. Freeze.
No, you're fine.
Your Honor, the prong of a claim for deliberate indifference requires that the plaintiff establish an objectively serious medical need. In Cinto v. Stansbury in 2016, this court held that a plaintiff's serious medical need is one that has been diagnosed by a physician as mandating treatment. Here, Mr. Moss's thyroid disease, PTSD, ADHD, and major depressive disorders have all been diagnosed by Mr. Moss's treatment and diagnosed by Mr. Moss's physician, and required treatment in the form of daily medication and continued follow-up care by a physician. This prong also requires that the defendant be deprived of adequate medical care that results in either a physical or emotional injury or a substantial risk of physical or emotional injury. By withholding Mr. Moss's thyroid medication from March 4th to April 11th, when he finally received treatment at Mashburn Medical Center, he was without his thyroid medications for 38 days. At this time, Mr. Moss's physician proclaimed it was a wonder he was not in a coma because his thyroid levels were so high. Looking to the joint appendix, page 148.
Ms. Weingartner, can I ask you about that the prison officials know, or the prison guards know about this issue regarding your client's condition, that he was almost in a coma as a result of the delay in receiving the medication?
Yes, Your Honor. Despite the fact that the defendants were non-medical personnel, they were put on notice that Mr. Moss had a thyroid disease and mental disorders. And that
No, I get that. I get that. But you just referenced a comment from the doctor about how he was surprised that your client wasn't almost in a coma because of the delay in receiving the medication. I'm asking you whether or not the prison officials knew that.
Yes, Your Honor. It's documented in the joint appendix on page 146 that Mr. Moss informed the defendants of what Mr. Russo, the doctor, said in that case, and they were aware of that.
But counsel, were they aware of it when they took the actions that you claim, or I'm not saying that allegedly led to the delay in providing medication? That would be the relevant time. Is there any allegation in this complaint that at the time the defendants did whatever it is they did that is being linked to the delay in medication, that at that time they understood that this was an emergency and that your client could go into a coma if he didn't get his thyroid medication immediately? Because the request didn't say anything about that.
Your Honor, Mr. Moss noted at the intake form on March 4th.
I'm sorry, I can't hear you. Sorry.
Had any better, Your Honor?
Yes.
Your Honor, Mr. Moss noted in his intake form on March 4th that he had these conditions. And
I'm sorry, we still can't hear you. I think the connection, maybe next time you all do this, you should practice. Not practice you, but see practice for the connection to see. I think this maybe just screwed up.
Yes, Your Honor. Is that any better for you?
Yeah.
Not much.
Should counsel call in with the phone?
Well, we're almost done, I think.
Yeah.
Your Honor, how is that? Any better, Your Honor?
Judge Harris's question.
Yes, and thank you for your patience, Your Honor. Judge Harris, the defendants were put on notice as of March 4th that Mr. Moss had this thyroid disease and these mental health conditions. When he was without medication, that is what allowed his thyroid levels to raise, or for example, his PTSD and ADHD, his suicidal thoughts to worsen during that time. So that the defendants were put on notice as early as March 4th should have been their indication that Mr. Moss needed adequate medical treatment at that time. And then it is a common sense perception that his condition would have worsened without the requisite medication.
See that, I think, so you're relying on just anybody ought to know that if there's a relatively short delay in getting thyroid medication, the results could be as severe as a coma, because I would not have known that. But
No, you're looking to Bryce v. Virginia Beach Correctional Center from 1995 in this court. A substantial risk can be inferred from circumstantial evidence or from the very fact that a risk was obvious. Here we have that Mr. Moss is without his medication for not short periods of time, but very long periods of time. And for his thyroid disease, it was 38 days without receiving medication. That's over a month. And for his mental health disorders, it was over 2 months on 2 separate occasions. And Mr. Moss's grievances show that he was suffering during that time and asking for help. I think very important to note out is that on the page 319 of the joint appendix, the district court even notes that Mr. Moss is experiencing suicidal thoughts at this time. Certainly those are a worsening of his symptoms during this time, and that he was attempting to inform the defendants of his worsening conditions without the medication.
Can I ask you just, this is a somewhat unusual deliberate indifference case in that the defendants are not medical providers, they're just prison officials. And just even objectively speaking, what are the allegations that sort of tie these two defendants to the delay in getting the medication? I mean, what is it that they did that was wrong here?
Your Honor, the defendants today are really the gateway to Mr. Moss's adequate medical care. There's a reliance on the defendant to not only provide Mr. Moss with access to the hospital, but also to pick up prescriptions once called in, and to distribute them to Mr. Moss once they were in the prison administration's possession. For example, looking to page 190 of the joint appendix, after Mr. Moss visited RHA on August 14th, it took a follow-up call by his physician the next day on August 15th in order for the defendants to go pick up the prescriptions at the pharmacy and distribute them to Mr. Moss. And this shows that it's much more than just access to a hospital or to doctors, but there's additional elements of care that are required under this amendment.
But once that call was made, they went ahead and picked it up, right?
On that instance, yes, Your Honor, they did, but a separate instance shows on page 151 of the joint appendix that Dr. Russo noted that he had actually called in one of Mr. Moss's prescriptions a month prior, and the defendants had simply failed to pick that up and altogether. And so that's another instance of the defendant.
But how do you distinguish that? I mean, it's clearly inattentive, perhaps negligent, but how does that amount to a deliberate indifference? I mean, they need to be aware of the risk, and they need to consciously ignore the risk. And you know, as your colleague on the other side points out, I mean, it was less than perfect, and they responded, albeit at a snail's pace sometimes, but they did respond. So it just seems difficult for me to understand how that can rise to the level of deliberate indifference.
Yes, Your Honor, if this was one instance of delay, that may be understandable, but here we have 3 separate instances of delay, one spanning 1 month, 2 instances of a delay spanning over 2 months. Looking to the 7th Circuit 2013 case, Smago v. Mitchell, a reasonable jury could find that these pattern of delays resulted in deliberate indifference, the fact that these things, if it's not just one instance of a few days, a long-standing delay over months at a time where Mr. Moss did not receive adequate medical care.
Counsel, when I am confused now, it seems that you're referring to some delays that happened after suit was filed on April 25th, right?
Yes, Your Honor.
Well, why can we look at those? Have those been the subject? I mean, they weren't the subject of a grievance if they happened after suit was filed, were they? I mean, don't you have to do the grievance before you file suit?
Your Honor, these grievances were addressed by the district court, and so they are included with the grievances that this court should consider when determining if there has been delay or denial.
I'm sorry, you want us to look at delays that happened after this lawsuit was filed?
Yes, Your Honor.
I mean, was the complaint amended?
Your Honor, I cannot speak to that. I will address it in rebuttal.
Okay.
For the foregoing reasons, appellant Mr. Moss respectfully requests that this court reverse the district court's order granting summary judgment and authorize the district court to appoint counsel on remand. Thank you.
Thank you. Mr. Ingersoll?
Thank you, Your Honor. And if it pleases the court, my name is Mike Ingersoll. I'm here on behalf
I can't hear you.
Oh, we're having the same problem with you.
It must be us. So it must be us.
Let me go grab my cell phone. Mike Ingersoll, and I'm here on behalf of defendants Denton. I'm here on behalf of defendants Denton, Sheriff Harwood, and I'm sorry. This threw me off a little bit. Please excuse me.
Mr. Banks, go ahead.
Mr. Banks, yeah, sorry. There are three primary issues here which the court has clearly already addressed. My opposing counsel has obviously addressed them, but they, for roadmap purposes, I'll go ahead and lay this out. There are a couple of questions that the court did ask that I want to address initially. But first, obviously, there's whether Mr. Moss actually exhausted his available administrative remedies under the Prison Litigation Reform Act. The sub-issue there is clearly availability, which the court has picked up on. The second issue is his deliberate indifference claim. That claim is clearly based on a delay in the provision of medical care, not the denial of the provision of medical care. And the third is qualified immunity to the extent the court feels that defendants were actually deliberately indifferent. And that comes with its own sub-issue of whether a reasonable officer under the circumstances would have known that their conduct would violate his constitutional rights. I would like to open by addressing, under the exhaustion issue, a couple of questions that were asked. Judge Harris, Judge Motz, and Judge Diaz, you all asked a question regarding whether a third party filing grievances on behalf of Mr. Moss was proper under the grievance procedure. And what I will say is that answer has, there are 4 parts to my answer. I'll hit them very quickly. The overarching consideration, though, is that through the course of Mr. Moss's incarceration, he filed grievances from the date of March 16, 2018, which is about the time that he was booked, through August 23rd of 2018. And the number of grievances, medical requests, and law enforcement contacts that were filed during that time totaled 27. Specifically, there was 1 law enforcement contact. That was the March 16th submission. And then there were 26 other either medical requests or grievances that were filed by Mr. Moss. The critical date here, though, is April 25th of 2018. That's the date that Mr. Moss signed and submitted his complaint for filing. Prior to April 25th of 2018, he submitted 6 either law enforcement contacts, medical requests, or grievances through the jail's kiosk system. The jail does have a grievance policy that's located at page 167 of the Joint Appendix. And if you turn to page 165 of the Joint Appendix, right before it, you'll see the declaration of Coy Phillips. Coy Phillips clearly states that the jail recognizes the kiosk as a recognized method of submitting grievances electronically to the jail. And that can be grievances, that could be medical requests, law enforcement contacts. So that sets sort of the picture of what we're dealing with here. Mr. Moss clearly showed a preference for filing grievances and medical requests electronically because every single one that he filed with the jail was filed through the kiosk. It is only during this narrow window, prior to him filing suit on April 25th, while he was in lockdown for the preceding 24 days, that Mr. Moss now contends he needed handwritten grievance forms and was not provided them. So with respect to whether the third party is filing on his behalf via the grievance...
Mr. Ingersoll, can I ask just a factual question? So could he have accessed the kiosk while he was on lockdown?
Could he personally have accessed the kiosk while he was on lockdown?
Right.
Not that I do not know the answer to that offhand, Your Honor. I apologize. I do not know for an hour. He was released for an hour per day, several times per week.
Well, the prison has never stated in any of its papers or had anybody make affidavit that he could access.
That is correct, Your Honor.
So I think we have to take the record before us that he couldn't while he was on lockdown.
Correct, Your Honor. And even operating on the assumption that he couldn't access the kiosk himself personally during lockdown, it doesn't erase the fact that, as Judge Diaz observed, there were actual grievances that were filed. And there were grievances that were filed during this period. And with respect to the due process claim, which is what the exhaustion defense applies to, he never at one time raised the issue of his disciplinary hearing while on lockdown. He filed 2 grievances while he was actually locked down.
But you see, this is what I don't understand. I thought hammered to us actually in your papers was that if you don't ask for a hearing, it's not a proper grievance. So then doesn't that defeat your argument that he filed all these grievances because he never asked for a hearing?
Let me be more specific, Your Honor. Thank you, and I will clarify. He filed grievances for other issues. He did not file a grievance related to any of related to his disciplinary hearing, which would give rise to his due process claim. He actually did not raise any issue with his disciplinary hearing until he filed his complaint on April 25th. The complaint is the first place where any complaint regarding his disciplinary hearing appears. And then the only grievance, or the first time he filed a formal grievance with the jail regarding his disciplinary hearing was almost a month later on March 24th of 2018.
Well, of course, he says he was prevented from doing this. And so you're agreeing, it's hard for me. You kind of are ships passing in the night on this. You seem to think that's important, that he didn't ask for a hearing and that he didn't file the formal grievance. He said he wasn't permitted to do that. So maybe talk.
Thank you, Your Honor. Yes. So he filed obviously several grievances before he filed his complaint. Like I said, he filed 27 total while he was.
But I thought you didn't regard those as real grievances. So you
we don't
call
regard
grievances for one purpose, but not for another.
correct, Your Honor. He did not file a grievance with respect to the due process claim. He didn't complain about the lack of a disciplinary hearing. That matters. His other grievances matter.
Counsel, I'm very confused now. Your claim, you concede that he filed a proper grievance on his medical treatment claim, correct? He didn't ask for a hearing on it, but it didn't matter. That was a proper grievance on the medical treatment claim that he filed while in lockdown, right?
Yes, Your Honor. Joint Appendix 175 was a proper grievance regarding his medical treatment.
Okay, and so your argument is he grieved one of his claims, but not the claim about the failure to give him a disciplinary hearing, which he did grieve, but only after he filed suit. Is that what you were saying?
Yes, Your Honor. Thank you for the clarification. Our exhaustion defense applies only to the due process claim, which is related to his disciplinary hearing.
But you are conceding he 100% properly grieved that medical claim.
Well, no, as a matter of fact, we're not conceding that. We just didn't raise it at the trial court, and I don't believe it's at issue here on this appeal. However, factually, there are multiple steps to the grievance process. He completed step one.
The initial grievance was fine, but he filed suit too soon after he grieved it, but you've waived all of that.
Yes, Judge Harris, absolutely.
But the initial, when he got allegedly someone else to go to that kiosk with his PIN and say, I'm grieving the denial of my medical care, that initial grievance, that was fine.
Yes,
step one.
As step one under the grievance policy for medical purposes.
But I thought the whole gist of your brief was that you had to have this in writing, and nothing ever was in writing, and it didn't work, and ask for a hearing. You had to ask for a hearing. So why am I so confused here?
I don't know.
Didn't you say do you want me to read you from your brief?
Yeah.
No, Your Honor. Let me explain. So you are correct. He did not file a proper grievance with respect to his due process claim. Therefore,
Well, what
he did not
about
properly
respect to the medical claim? Did he ask for a hearing there?
No, he did not ask for a hearing regarding.
Well, then what about all this stuff in your brief about you have to ask for a hearing in order to have a grievance? Maybe I've misread your brief. So is that not your position?
No, Your Honor, I don't believe you've misread the brief. I believe I've done a poor job of explaining it here today. Let me explain with respect to how this ties in, how the failure to grieve his due process claim ties in to third parties filing other grievances on his behalf, if you would give me one moment. Mr. Moss, on page 11 of his opening brief, states that the jail, thwarted his attempts to exhaust his administrative remedies. 4 main points on that. Every single grievance had his name on it, as Judge Diaz observed. Every single grievance was submitted via use of his PIN at his direction. Every single grievance also included any content that he directed those third parties, I believe Miami and Tennessee were their names. It included any and all content based on the record that he wanted included in those grievances. And he chose not to grieve anything related to his disciplinary hearing. The record is devoid of anything that indicates Mr. Moss asked Miami and Tennessee or some other unknown third party to submit a grievance via the electronic kiosk on his behalf using his PIN under his name. And yet they didn't include everything he asked them to include in it. Counsel says it was that he focused only on his most pressing issues, his medical issues, which I'll get to in the deliberate indifference section. But there's nothing in the record, and the burden is on Mr. Moss, now that we've raised the deliberate indifference defense, that we've raised the exhaustion defense to show that he did properly exhaust. Mr. Moss has submitted nothing, and there's nothing in the record indicating that anything he asked any third party to submit on his behalf from a content standpoint in these grievances or medical requests was not included in those grievances. So the grievances and the medical requests that he did manage to file, that were filed on his behalf by third parties prior to filing suit, and again at any point afterwards, to the extent they're relevant, which we don't think they are, they all included every word that he wanted included. So the characterization of this as a game of telephone is really a distinction without difference. and whether a third party is permitted to submit grievances under the Prison Litigation Reform Act on behalf of another pretrial detainee, such that that pretrial detainee has exhausted his available administrative remedies and that those administrative remedies are available to him in the first place, that's a form over substance position. The fact of the matter is, the practical facts are, there were over 24 grievances or medical requests that were filed. There were several that were filed directly before the point that he filed his lawsuit, and none of those prior to filing his lawsuit included any complaint regarding his disciplinary hearing.
Okay.
Therefore, he failed to.
We have his testimony on what happened, right? But you can't ignore, right? He asked defendant Banks for a disciplinary hearing, and Banks said, I'll pray for you. Plaintiff asked defendant Banks and Hartford for access to the kiosk to request medical treatment and grievance procedures. But he was told, absolutely not. You're SIC on lockdown. Now, as of April 25th, plaintiff was still on lockdown. Officers refused to bring in grievance forms, and he is not allowed on the kiosk to submit grievances and medical requests. He gave a sworn statement about all this. So what do we do with that? If that's true,
Again,
he's got a case, right?
well, accepting is true. He requested that he had access to the kiosk in order so that he personally could file a grievance with respect to his disciplinary hearing. Based on that testimony, accepting that is true, that happened. It doesn't negate the
for
fact.
access. He doesn't say that I personally would have access. He says that he asked them to get on the kiosk so he could request medical treatment and grievance procedures, but he was told absolutely not. You're on lockdown. He asked for a disciplinary hearing, and Banks said, I'll pray for you. Do we just decide that he's not credible? We decide that? Maybe he can't prove
Your
that.
Honor, the line of thwart cases that Mr. Moss cites in his briefing is directly relevant to this. The issue is whether his efforts to file these grievances were thwarted by the jail official's conduct. They clearly were not thwarted. The end result was that the grievances were filed. They were filed under his name. They were filed with all the content we have to assume that he wanted included in there.
No, counsel, just a minute ago, you said, yes, grievances about his medical care were finally filed, but that he never asked for a disciplinary hearing. That's been your consistent argument. He says he did.
Yes, Your Honor, and he did not take the opportunity, though he was filing grievances and having others file them on his behalf, and they were filing exactly what he was asking them to file. He did not also ask them to file any language in any of those grievances regarding his disciplinary hearing.
But he didn't have to do that. He asked for it at another time. You can't. It would be like when we had a regular lawsuit and you would say to opposing counsel, well, you have to make this argument second. You can't make it fifth. I mean, he controls when he makes it. He says he did this. And if he did ask them and they said, I'll pray for you, or that he absolutely would not, they would absolutely not do this because he was on lockdown. He's done all he can do. He's been denied the access.
Well, not necessarily, Your Honor. Mr. Moss cites, let me rephrase. There was a case out of the Middle District of North Carolina. The case site it's not cited in our brief. It's 2010 WL 2471906.
What does it say?
That is the Rogers v. Davidson County Detention Center case. In that case, Judge Flanagan out of the Middle District in North Carolina found that because the inmate plaintiff filed a federal lawsuit only 4 days after he submitted a grievance regarding the basis of that lawsuit, that number one, he clearly had the administrative remedies available to him because number one, he filed the grievance. And number two, he chose to file the federal lawsuit instead and has to live with the consequences of that decision. There's another case, Hardy v. Turner, 2011 WL 2173624, stands for the same proposition.
Counsel, let me, if I can just back you up a little bit. I mean, I think I understand the upshot of your argument. It's that we'll accept everything he said, all of the allegations. They wouldn't give him forms. They wouldn't let him personally access the kiosk. But the grievance process was available anyway because he was able, sort of heroically, to figure out this workaround and get someone else to do it for him. And doesn't that strike you as just a little bit counterintuitive that, like, the prison could have said also, like, you know, we're going to keep you in your cell. You can't talk to anyone. We're going to make sure you also can't have a third party do it. But he manages to, like, throw a note out the window. I mean, I'm talking now from stupid movies, but, you know, he attaches it to a pigeon and it gets to another inmate. And now the inmate files the grievance. Like, how is that grievance system available to him? I mean, the prison officials have done everything they can to thwart his access. It is the fact that sort of he is a superhero and can figure out some way around it. It's a bit counterintuitive to say, okay, so no harm done, we're all fine here.
Well, Your Honor, I would respectfully disagree that the prison did everything they could to possibly thwart him from accessing the system. If they wanted to thwart him from accessing the system, they could have cut off his kiosk access at some point before July of 2018, which is the point at which they did cut off his access. That's Joint Appendix 137, which is cited also in Mr. Moss's reply brief at page 6. So it was not until July, well after he was released from lockdown, that his kiosk access was actually shut off. Counsel also cites the Hill v. O'Brien case, which is commensurate with the Hardy decision. And the Hill v. O'Brien case and the Hardy decision, that line of cases deals with efforts by the jail staff to make misrepresentations, to make misleading statements towards inmates, or to altogether threaten. Sorry, go ahead.
Let me try to rephrase my question. Say that Mr. Moss had not figured out this workaround, and we're accepting all of his allegations. They denied it. He asked for a written grievance form. He says, I can't get out of my cell to use the kiosk. I need the written forms. They say, you can't have the written forms, you know, good luck. And he doesn't figure out a way to file a grievance. Would you still be here saying the grievance system was available to him? He should have figured out a way around the roadblocks we threw up? Or is this just sort of a happy fortuity for the prison system that, you know, you guys are just lucky he figured out a way? But had he not figured out a way, you would have had to concede you guys thwarted his access to the system. Do you see what I'm saying?
If he absolutely was unable to file any grievance whatsoever through any means, then yes, we would have thwarted his
No, I'm saying, what if his allegations were exactly what they are here, and in fact, while he was on lockdown, he had not filed any grievances?
Under those circumstances, we likely would have, quote, thwarted his efforts with, I do want to make the caveat that under the O'Brien case, under that line of misrepresentation and threat cases, the inmate has to receive that conduct. That conduct has to be bestowed upon them. They have to be threatened. They have to be misled. Misrepresentation has to be made to them. And the inmate has to actually believe that their efforts are thwarted and that there is no possible way that they can file a grievance. That is clearly not the circumstance here. Because
no, I understand, but I think your concession is wise. In my hypothetical, if he was alleging I wasn't allowed to use the kiosk, I asked for forms, they wouldn't give me any forms, and that's why I didn't file any grievances, we would have a very different case.
Yes, Your Honor, I agree. And it looks like my time is up. I'm happy to answer any questions. Otherwise, I will yield my time.
Actually, just wait a minute. Judge Diaz, do you have questions?
I don't. Thank you.
Judge Harris? Okay, thank you very much. Appreciate your argument.
Thank you, Your Honor.
May it please the court. Your Honors, I have two issues to raise on rebuttal. The first is that the defendants have the burden to show that they complied with their portion of the administrative policy. The defendants provide no evidence. Their sole witness does not provide any testimony, nor do they provide any affidavits to the effect to rebut Mr. Moss's assertion that he was denied access to his administrative remedies. This court held...
I'm sorry, counsel. Can I ask you a question about the record? And I'm sorry to sort of take you in a weird direction. But it does seem, I wonder whether this claim maybe doesn't work as an exception to exhaustion, but it does seem like on these allegations, the prison nevertheless did not comply with its policy and try to assuming the allegations are true, tried to deny access to its grievance system. It's just that it was unsuccessful. And that might be a standalone claim. But it looks like maybe there was a standalone claim. You violated my due process rights by trying to stop me from using the grievance system, and that was dismissed, and that is not on appeal. Is that what happened?
Your Honor, the due process claim is something that we would request to be considered at the district court level. However, here, in order to be able to get back to the district court, we would request that you find today that he was denied.
No, you're misunderstanding. I'm sorry, and maybe I wasn't clear, and I will only try one more time, and then we can move on. I thought that at a very early stage of this litigation, the district court, I'm not talking about the denial of the hearing due process claim. There was a separate due process claim saying you also violated my due process rights, not by denying me the disciplinary hearing, but by trying to keep me out of the grievance system. And the district court, I think, dismissed that on frivolity review, and that is not before us. Is that right?
That is correct.
Okay.
Your Honors, I see that I'm out of time on rebuttal. May I take
10
seconds to wrap up? Your Honors, I would like to point the court to the holding of the Supreme Court in 2016 in Ross v. Blake, in which the Supreme Court stated that the standard is consistent denial. When I was speaking to you previously, you had asked about the April 22nd grievance, which was filed on Mr. Moss's behalf by another inmate. The Supreme Court stated in Ross v. Blake that the standard and the remedy is unavailable when a remedy operates as a simple dead end, with officers unable or consistently unwilling to provide any relief to aggrieved inmates. And that is the standard that is being met in this case by Mr. Moss's consistent denial.
Counsel, can I follow up on that that citation? So was that Supreme Court case a case where, notwithstanding the denial of access, which it seems on this record seems to have been made, that the inmate there actually was able to file a grievance, or was that the kind of claims Judge Harris just asked you about, due process claim for not allowing access?
Your Honor, the Supreme Court outlined 3 different means of a remedy being unavailable to an inmate, and that was one of the 3 means on which the remedy was considered unavailable to an inmate and then unable to be exhausted under the Prison Litigation Reform Act. I can get you those 2 other claims after completion of today's argument.
Well, I was just asking a factual question as to whether or not that case is on all fours with this one, where you have a alleged denial of the access, but an inmate nonetheless is able to file grievances. That's not, that wasn't the, was that the, were those the facts in that case? Do you know?
No, Your Honor, those were not the facts in that case, but this statement from the Supreme Court is persuasive here for you all. And I will pass my over to my co-counsel.
May it please the court. Appellant has 2 additional points for rebuttal. And the first point is that when the district court considers the grievances post April 22nd, as it did for those grievances submitted in May, looking to page 332 of the joint appendix, and in August, looking to page 333 of the joint appendix, then the complaint has been amended by implication. An appellant will address this further in supplemental brief if the court would like. Additionally, it should be noted that Mr. Moss is a pro se litigant at this time, and some flexibility should be given to his pleadings. In addition, the second point on rebuttal is that this was not one short instance of a single delay, rather 3 instances of delay, each spanning over 1 month, and 2 of those delays spanning over 2 months. In order for Mr. Moss to receive adequate medical care under the 8th Amendment, he needs to be entitled to not only access to hospital treatment, but also have time and distribute time. For the foregoing reasons, appellant respectfully requests that this court reverse the district court's order granting summary judgment and authorize the district court to appoint counsel on remand. Thank you.
Thank you very much. We appreciate your arguments. Notwithstanding our difficulty to hear everything, and go directly to our next case.
Thank you, Your Honor.
Do we have both lawyers with us? Mr. John?
I thought I might test out my value of Virginia. Your Honors, this case does not involve constitutional issues of deliberate indifference for failure to provide medical care and the sort of arguments that we just heard. It does not involve an enormous amount of money, and it's certainly not the first time that this court has been called upon, nor will it be the last that the court is called upon to referee a fight between two insurance carriers over who should pay what when. So perhaps it does not have any unique appeal to the court, but I think it's an important case nonetheless because it implicates questions of federalism. And state law has long been the governing source of law for any issue of contract interpretation. This court has recognized that repeatedly. And that's particularly true in the context of insurance policies, which are heavily regulated by the respective states. In Virginia, for example, we not only have a statutory scheme governing insurance, but a specific administrative agency, the Bureau of Insurance, that actually prescribes certain policy language that needs to be included in liability policies that are issued within the borders of the Commonwealth of Virginia. It makes sense then that the Virginia courts would be the appropriate judicial body to interpret insurance policies delivered in Virginia and to develop rules for how to resolve the type of dispute we have here, where you have two policies with conflicting other insurance provisions. With that in mind, this appeal largely boils down to the question whether Virginia would adopt the logic of the Horace Mann versus General Starr case, which was the primary, if not exclusive, basis for the district court's opinion below. Horace Mann versus General Starr was a 2008 case from the Fourth Circuit in which the Fourth Circuit forecast that West Virginia, not Virginia, but that West Virginia would follow what we've referred to as the true excess rule. And under the true excess rule, a court looks at the general insuring intent of a policy or a broad classification of an insurance policy as either primary or excess to determine which policy has a priority of coverage in any given case. We appealed the district court's decision relying on the Horace Mann case because that logic of Horace Mann cuts against decades of Virginia law. And I'll focus primarily in my comments today on that point, why Virginia would not subscribe and does not subscribe and has never subscribed to the Horace Mann rule of the true excess rule. I'll note at the outset that the true excess rule has some appeal because it is convenient and it's a shortcut to quickly resolve these issues, which can become very complex looking at the competing language in two policies. The Horace Mann true excess rule uses a broad one-size-fits-all framework in which a court may rely on generalizations about the policy's intent rather than delving into the specific policy language as applied to the facts giving rise to a given lawsuit claim.
Mr. Johnson, can I ask a question? You said it has some appeal because it's convenient, but I thought part of the reason why the district court and the Horace Mann court seemed to think that this sort of looking at broader policy intent and priorities was important is because as a practical matter, there are differences, at least in terms of the risks that are being taken on by these different policies. We have a true excess policy, as I understand it. The premium is calculated accordingly because the understanding is that it is the last line of defense in terms of coverage. And then where you have a policy at least as the district court characterized your client's policy that has attributes of both primary liability that attaches to it along with an excess clause, that policy would be priced accordingly to reflect the level of risk for that policy as opposed to a true excess policy. That seems to have some intuitive appeal and seems to make some sense. Why is that wrong?
Your Honor, I'll answer your question in two ways. First of all, specifically with regards to the premiums charged, you're comparing apples and oranges when you look at two different policies. For instance, our homeowner's policy doesn't just cover liability. It covers Mr. Hooper's home and his property, which is a completely different process for assessing a premium. Conversely, the federal policy involved in this case had an enormous premium because it was delivered as a group policy to over 90 employees of a local investment firm here in Richmond. So there's no way to really, nor was there any evidence before the district court, by the way, to make an assessment or comparison of the premiums charged.
But am I remembering right that was part of the rationale that and I think you're right, that there may have not been any evidence about the particular premiums here, but that seems to be one of the policy justifications, is that in general, the risks are different, therefore the premiums charged are going to be different, and so it makes sense to allocate the risk accordingly.
That is correct, and the district court made explicit reference to that in its opinion, which we believe was inappropriate for that reason. I think the more fundamental response to your question in this regard, Your Honor, as to whether the policies are really trying to cover different levels of risk, it goes back to my fundamental point about Virginia law. Insurance carriers in Virginia are free to craft a policy that specifically delineates or allocates risk for different events that might occur. And you can see this in our own policy. Suppose Mr. Hooper, instead of having a fatal accident involving his operation of the boat, suppose he had accidentally discharged a firearm that led to his friend's death. Well, our policy would cover that directly and primarily. But that's one type of risk. Our policy specifically, when you look at the language in the policy, Mutual Assurance Society says, we will not cover your use of a watercraft except in very limited circumstances, including your permissive use of another's boat. And when we do that, we're only going to do it on an excess level. And I think this really gets to the crux of the issue, Your Honor. When you use broad classifications or labels about what a policy is intended to do as a whole, which is what the district court explicitly did. She looked at the general insuring intent. You lose the details that are often, and the fine print that are often the important substance of any contract. And one way to conceive of that, Your Honor, is, and actually there's a quote in the district court's conclusion, and this is in the judicial appendix at page 251 to 252. And I really think it encapsulates the problem that we see under Virginia law application of the true excess. District court wrote, quote, the society's argument improperly focuses on discrete subsections of the policies rather than the effect of the policies as a whole, period, end quote. That's a fairly remarkable statement because what it suggests is that the court should look at the general purpose of a contract and ignore the fine print. But that is exactly how you interpret contracts, is by looking at the precise terms used. And Virginia courts have recognized that over and over.
Counsel, I didn't read the district court the same way you did. I thought the district court was just saying, I'm looking at all of the text of all of the fine print in these contracts, whereas your position is that the entire sort of plain meaning inquiry should start and end with, you look at these two other insurance clauses and you ask one question and one question only, are they reconcilable? That's the whole of the analysis. And I understood the district court to be saying that's too narrow a take on the plain meaning of the contracts as a whole.
And I would agree, you don't simply look at the other insurance clauses, but what you do have to do is look at the specific terms of the policy that would apply to this loss, to the facts giving rise to the loss. And as I mentioned before, when you do that, you see that our policy covers Mr. Hooper's permissive use of his parents' boat, but it only does so for that specific risk on an excess basis. And that's been recognized by the Virginia Supreme Court in the Continental versus State Farm case we cited.
So, can I ask you a question, counsel? So you started with Horace Mann, which seems like a good place to start to me. And, you know, we held that because this true excess rule is so widely adopted, you know, it's a consensus rule. For that reason alone, we said we would predict that West Virginia would adopt it. So I feel like we need some way to distinguish Horace Mann here. And I don't think that saying, well, Virginia applies this kind of, basic interpretive canon that you look at the plain meaning of the contract is going to work, because so does West Virginia and so does virtually every state. And yet they've all also adopted the true excess rule. So is there some other reason to think Virginia would not adopt that rule, would want to be an outlier on this point?
Your Honor, that's a broad question I could spend the rest of my time answering. So let me try to be brief in responding.
Well, it seems pretty important, right?
It is. It absolutely
Your
is.
best answer.
It absolutely is. First of all, I'm not sure that Horace Mann is the practically universal rule. The district court cited cases from 12 jurisdictions that have applied the rule, which is not exactly a majority. Moreover,
well, has anything changed since? I guess one way you might distinguish Horace Mann is if the status of the true excess rule has changed since Horace Mann. Has it, in your view, is there any reason to think it has become less universal?
No, ma'am. I would
Okay.
not say that. But what I would say is that a number of states, like Virginia, and recognize that the Horace Mann rule has been around long before Horace Mann. It's been around for decades. The Fourth Circuit did not create that rule with Horace Mann. It simply adopted it on behalf of West Virginia. But no court in Virginia, no state court in Virginia, has ever mentioned, much less adopted the Horace Mann rule, either before or after Horace Mann was decided. And they haven't done that because they've been very clear, as the Nationwide versus Erie case decided in 2017.
Mr. Johnson, that they haven't rejected it either, or else you would have been telling us about that.
That's correct. They've not rejected it. They've not adopted it. They haven't even addressed it, because when you have a case in Virginia with conflicting other insurance clauses, the Virginia Supreme Court and various circuit courts have repeatedly noted you have to look at the policy language to see if they can be reconciled. That is a different approach than the generalized classifications of the true excess rule. And the Nationwide court, which again was decided, I'm sorry, did I interrupt?
No, it's okay.
The Nationwide case, which was decided in 2017, almost a decade after Horace Mann, the Virginia Supreme Court reiterated, and this is from page 340 of that opinion, and I'm quoting, "In determining coverage priorities between escape or excess policies, normal principles of contract interpretation apply. We look to the contract to determine the specific risk that is covered." And that is why, under Virginia law, and that's long been the case, going back decades, that is how we handle these issues. The other case that I would direct the court's attention to is USAA versus Travelers, 240 Virginia 214, a 1990 Supreme Court case. And the reason why I'm referencing that in response to Judge Harris's question is because one of the insurers in that case specifically urged the Supreme Court to adopt a general rule of insurance. In that instance, it was the general rule that the policy in place on an automobile comes in first, and the policy in place on a driver comes in second in terms of priority when there's an accident. Another general rule that, frankly, would be easy and convenient to apply in many cases. The Virginia Supreme Court rejected that. It explicitly said we won't resort to the general rule, and looked instead at the specific language in the policies to determine which insurers covered the risks that were presented on the facts that were involved in that loss. And so for that reason, we don't think that Virginia would adopt the Horace Mann rule. It runs counter to decades of Virginia law in which we look to the specific policy language to determine what risks are being covered. And when we do that here, this comes to, I think, the second, and we mentioned this a moment ago, the second fundamental issue with the district court's opinion. At page 246 of the appendix, part of the district court's judicial memorandum opinion, the court wrote that because the society's homeowners policy does not ensure the same level of risk as the federal policy, pro rata sharing of the settlement burden would be inappropriate, end quote. That is incorrect, and it demonstrates the problem with using this shortcut under Virginia law. Both the policies cover Rand Hooper's permissive use of his parents' boat, and both do so only on an excess basis. So I think, and going back to the point about making sure you look at the specific language in discrete subsections were the words that Judge Locke used in her opinion. if you don't look at the specific discrete subsections, there may not be coverage at all. You may have a policy that the general insuring intent is to provide liability coverage, but there's an exclusion that applies for the given facts that give rise to a loss or claim. So the first thing you do with any insurance question is look to the policy to see if the risk is covered, and if so, at what level. And that's the part of the analysis that the district court gave short shrift to, because it opted instead to follow the generalized approach of the true excess rule. I'm running short on time, save for my rebuttal, but I'm happy to answer any questions. Otherwise, I'll cede the floor to Mr. Weingart.
You've used all your time.
Yes, ma'am.
You're on mute.
Go ahead, sir.
Thank you. Sorry about that. Rookie mistake. May it please the court, my name is Doug Weingartner, and I represent Federal Insurance in this case. And not surprisingly, our position is that the Horace Mann opinion, which reflects the nearly unanimous majority rule in every jurisdiction that's looked at it, should apply here and ought to apply here. And there is no reason why it not apply here. The Horace Mann rule generally states that a true excess policy is secondary in priority to a primary insurance policy, even with respect to an incident for which the primary policy purports to make itself excess to any other available insurance. That is directly on point here, because that's exactly what the society is trying to do. It is trying to posture itself as an excess policy when it is not.
Well, I mean, it's not trying to posture itself as an excess policy. The policy language says exactly what Mr. Johnson's recited. And I guess I'm having, you recite the rule accurately. I've always struggled, I've been struggling with why that makes sense. What's the policy rationale for that kind of an exception to not looking to the contract language?
I will answer that question, but first let me address some disagreement with the form of the question itself. The rule does not ask you to not look at the contract language itself. The rule asks you to look at the entire contract language, not just the other insurance clauses. All primary insurance policies, almost all of them, have other insurance clauses where insurance companies try to arrange the priority of coverage among them. In fact, the Nationwide case in 2017 that counsel cited earlier was a dispute between primary insurance policies dealing with other insurance clauses. That's the classic dispute. And the issue here is not the classic primary versus primary policy, but where you have a primary policy versus an excess policy. And the true excess rule says you cannot turn a primary policy into an excess policy simply by using the other insurance clause language. It is a primary policy. It is always a primary policy. And it is only offers excess coverage under very limited certain special circumstances, which do not.
Right, but I understand that. But I guess the question is, in this case, it's a very risk that is covered by that excess language. So why shouldn't we just simply read it literally?
Well, first and foremost, the policy itself, and if you give me one moment to point to the joint appendix, the watercraft coverage that is at issue here is listed on joint appendix page 90 under one of the incidental liability coverages. It is not identified as an excess coverage, and on page 90 where it covers watercraft, it uses the classic language connoting primary liability. This is a liability policy. This is a liability section of the policy. The other insurance clause comes afterwards on page 96 of the joint appendix, and that is where it says this watercraft insurance is excess over other valid and collectible insurance that applies to the claim. So it is the watercraft coverage is indeed primary. It is excess only as to other valid and collectible insurance. And
Is it primary as to, is it primary as to a permissive user of the watercraft?
Yes, it's primary to everything. The watercraft coverage is primary with the exception of it is excess over other valid and collectible insurance. The term valid and collectible insurance, as we briefed from the Jones versus Maddox case from, I believe it's 1981, DC Court of Appeals, which was approved and adopted by this court in medical protective. The Jones versus Maddox case said that term valid and collectible insurance is a term of art or connotes other primary insurance. Okay? Valid and collectible is a synonym for other primary insurance. So this policy makes itself excess over other primary policies. It does not make itself excess over other excess policies. It is a primary policy. And that is where the broad intent it ought to be and should be determined first before you even get into the situation of parsing the language of the other insurance clauses.
Mr. Weingartner, can I ask, a follow-up? So, but on your theory of this, the true excess rule, it wouldn't matter if the policy was acting as a primary policy with respect to the particular risk at issue, so long as it had components of primary liability that attaches to it, that is part of the policy, but then also purports to have an excess, rule as an exception. That is not a true excess policy. That would not be considered to be a true excess policy and wouldn't be applied as such, regardless of the risk at issue. Is that right?
I always hate to say never ever, but I think that is absolutely correct. You look at the broad intent of the policy languages, the broad intent of the defining insuring language, before you look at and compare the contrasting other insurance clauses that may be in those policies. Here, and I can say this for another part of the argument, here, when you do compare and contrast the language in the other insurance clauses in the federal policy versus the society policy or the mutual policy, they are widely different. They are dissimilar. They are not nearly identical in effect at all. So under the second part of the rule with regard to this comparison of policy language, they are not mutually repugnant and the pro rata rule does not apply. When policy languages are, the other insurance clauses are dissimilar, you can reconcile the language and determine from that who is primary and who is excess. And when you go through that analysis.
Counsel, just to clarify, I'm sorry, because it's hard for me. This is your alternative argument, right? Forget the true excess rule. We win even if you do go down the other path and compare and contrast, limit basically your question to whether these two clauses can be reconciled. So this is alternative to the true excess rule.
Correct. And to that
Okay.
point, in the Stratco Company versus Ward case from the Virginia Supreme Court in 2012, it states the simple rule that insurance policies, like other contracts, must be interpreted in accordance with the intentions of the parties as gleaned from the words used in the document. And when the terms of the contract are clear, the contract must be construed according to its plain meaning. That is what the court was referring to and what Your Honor, Judge Harris, was referring to with regard to the broader intent of the policies. And that broader intent must be looked at first. And that's the logical basis upon which Horace Mann flows. That's exactly what Horace Mann says one ought to do. Let's look at the broader intent of the policies and determine what the intent of the parties actually was before we have to deal with parsing the language of other insurance clauses that may be in those policies. Here, that broad intent is gleaned from the plain language of the policy, where the federal policy says it will pay only for covered damages in excess of all underlying insurance covering those damages. And that policy requires policyholders to maintain in full effect primary underlying liability insurance. The district court found that to show that the federal policy unambiguously covers only a loss upon the exhaustion of underlying primary insurance and bears the hallmark of a true excess policy. The society policy is undeniably a homeowner's policy. Everything about it declares it to be a liability policy, including the watercraft coverage. And the other insurance clause that tries to turn it into excess only does so with regard to other primary policies. So we are indeed comparing apples and oranges here, which is what Horseman says you shouldn't have to do. A primary policy with an other insurance clause, whether it's an escape clause or an excess clause, is only effective as to other primary insurance policies with an escape or excess clause. Couch on Insurance dealt with, I'm sorry, one moment. Couch on Insurance, which is cited in our brief for one moment. Section 220.41 of Couch on Insurance. This is long before Horace Mann was decided. As a rule, excess and umbrella policies are regarded as excess over and above any type of primary coverage, excess provisions arising in regular policies in any manner, or any escape clauses. So this is not just Horace Mann creating a rule. This is the entire body of the general rule of the entire body of insurance law generally. And there are no cases cited in the briefs and no cases known to exist by myself in which Virginia has said anything adverse to the true excess rule, anything adverse to Horace Mann. And in fact, the way that rule works is entirely consistent with Virginia law, which requires one to look at the general intent of the insuring parties under the case I cited earlier. So I think that answered, did that answer your question, Judge Diaz?
It did, but I have a follow-up. Your colleague on the other side cited two cases, the Allstate case and the USAA case, and he cited one or the other for the proposition that Virginia, in fact, would not apply this sort of general intent way of interpreting contracts. And the case he cited had the proposition of an auto insurance policy that applied to both the automobile and to the insured. And he said that in that context, the Virginia courts would simply look at the language of the policy and not try to glean a general priority based on intent. So can you talk about that?
Right, and Judge, I don't claim to be an expert in that case. However, my recollection of it is that it was in a posit. It doesn't deal with this issue whatsoever. It deals with primary policies involving automobile liability. And I think what the court was trying to say there was where one was arguing that a certain vehicle should always come first in terms of who has first coverage in competing primary policies. We're not going to create a general rule that this car always comes first here. That's completely dissimilar from and has no connection to this issue where you have you don't have the same public policy interests of motor vehicle coverage, such as the omnibus clause and all those things that are required by, I think it's 38.2206 that deal with automobile policies in general. So that case doesn't have anything to do with our situation other than in one circumstance, the court said, we choose not to have a general rule here. We want to do it on a more case-by-case basis. That doesn't apply to this situation. And the nationwide case from 2017 that counsel cited to for the idea that the Supreme Court indicated that one should look to contract interpretation as between escape clauses and excess clauses, that was absolutely a contest between two primary policies. And that principle that nationwide stands for is not controversial at all. It simply says where you have two primary policies with two competing other insurance clauses, you look at that language. That's all that case says. It did not involve this issue of excess policy versus primary policy. So,
Okay.
Understand your argument? I'm sorry, go ahead, Judge.
yes, ma'am. Did I interrupt you, Judge Mons?
No, Judge Diaz, I think, has a follow-up.
Oh,
No, I'm fine. Thank you. Go ahead.
No, I was just going to say, I think, understand your argument. You don't have to use all your time. If you have more to say, go ahead.
I was told as a young lawyer, when a judge tells me that you ought to close your mouth. So I think I will close my mouth at this
I was
point.
told that too, but I'm not really telling you that you've won. I'm just telling you, we understand your argument.
I believe that the court understands the issues, and I stand by to answer any questions you might have.
Okay, thank you. I don't think we have any questions. So, Mr. Johnson, do you have any rebuttal?
I do, Your Honor. And first, I appreciate Mr. Weingartner's brevity. I had a hearing in state court yesterday that should have taken about 15 minutes, and it lasted an hour and a half. Lawyers reading cases to the court. So let me begin with I think what is the fundamental point of our argument. And Mr. Weingartner said that just because a primary policy has another insurance clause, that doesn't make it excess to an umbrella policy. And I want to be clear about something. We're not saying that the Mutual Assurance Society policy should be excess to any other primary liability coverage in general because it has another insurance clause. What we are saying is that with regard to this specific risk, to Judge Diaz's point, with regard to this specific risk of Mr. Hooper's permissive use of his parents' boat, that our policy only provides excess coverage. That's the starting point for this analysis. We provide the same coverage for the same risk at the same level as the federal policy in this case. And perhaps, Judge Harris, that is what distinguishes this case from Horace Mann. We're talking about not a general claim that our policy should always be excess.
No, I think that's exactly like Horace Mann. And this will actually help me. My understanding, but tell me if I'm wrong, is that your argument is limited to the argument that this true excess rule should not apply. But if it did apply, if the rule from Horace Mann applied, then you are not arguing that the district court misapplied that rule, correct?
I believe that's correct, Your Honor, if I understand your question.
Okay.
If Horace Mann and the true excess rule does apply, then yes. I
mean, I'm pretty sure that's the whole point of Horace Mann, that we're not looking at a risk. We're not doing a risk by risk analysis. That it doesn't matter that you are excess as to one risk if you are not a true excess policy. Isn't that the point of the rule?
Yes, ma'am. And that's the fundamental error with the rule under Virginia law, because in Virginia you have to look at the specific risk being insured. That's the starting point. Under all of these cases under Virginia law, you have to look at the specific language of the policy to determine what risk is covered and at what level.
Okay, and you think that is not the rule in West Virginia? West Virginia has a different rule. You don't look at what risks are insured. You just don't pay any attention to that. So that's why this is fine for West Virginia, but it won't work in Virginia.
Your Honor, I think that question really boils down to whether this court properly forecast that West Virginia would adopt Horace Mann. I'm not aware.
Right, so you think Horace Mann is wrong, but I'm trying to figure out if Horace Mann is right. If we were right in Horace Mann to say West Virginia, even though it has the exact same background contract principles as Virginia, would adopt this rule, how can I distinguish that if Horace Mann was right?
If Horace Mann was right in interpreting West Virginia law and forecasting West Virginia law,
right?
Your Honor, I want to be candid. I don't consider myself an expert in West Virginia insurance law. I know Virginia insurance law. I don't know West Virginia insurance law. I don't know.
Well, why don't you assume for purposes of this question that West Virginia law also says that they look at the plain meaning of the entire policy, that they would not neglect to look to see whether there is coverage in the first instance before they start talking about what's a true excess policy and what's not. Just assume they have the same background principles of interpreting insurance contracts.
Then respectfully, I think the Fourth Circuit got it wrong with Horace Mann, again, for the principles of federalism that I mentioned at the outset. And what I do know is that the Virginia line of Supreme Court cases is extremely clear. that you have to look at the specific risks in these two policies and how they're covered to determine whether there's a conflict that can be reconciled or not. I also want to very briefly address Mr. Weingartner's point that valid and collectible means primary insurance. That cites to the Jones versus Medex case, which was District of Columbia law. And frankly, that would violate every concept under Virginia law of following the plain meaning of language and not inserting a term like primary in the phrase other valid and collectible. The Nationwide versus Erie case from 2017 dealt with a similar question and said that it's meaningless semantics to say that any insurance or any other insurance or other valid insurance somehow means something different. And so here the phrase other valid and collectible insurance in our policy certainly does bring us to the level of excess insurance. And because you cannot give effect to the federal policy without eviscerating the mutual assurance policy, the two policies are in conflict and mutually repugnant. I see that I'm out of time. If anyone has additional questions, I'm happy to answer them.
Now, we thank you both for your arguments, and I hope the next time we see you, maybe it'll be in Richmond. Thank you.
I hope so too, Your Honors. Thank you very much.
Thank you, Your Honor.
And ask the clerk to adjourn court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.